Welcome to another webinar in our ISDS Webinar Series. It is my great pleasure to welcome you today. And of course, thank you for taking the time from your busy schedules to attend the webinar. We do look forward to your questions and engagement otherwise. Apologies, I just needed to mute someone. Okay. Apologies for that. Right, so today we're going to talk about, we have our wonderful guest with us today, Ms. Anja Ipp from the Climate Change Council. And I'm sure that most of you have been familiar or are familiar with the recent Climate Change Council report, reviewing jurisprudence under the Energy Charter Treaty and kind of doing a deep dive into the relationship between that jurisprudence and climate change, and generally transition to net zero and kind of green economy, and offering some lessons and key takeaways from the existing jurisprudence. So last week we had Dr. Krina Balta with us, so we talked about the modernization process, and we, like we will do today, did a deep dive into the modernization process. Now, the modernization process with the proposed changes and amendments in terms of both the definitions of the investor, investment, defining economic activity in the energy sector, as well as introducing some new provisions such as a standalone provision on the right to regulate, a standalone provision on sustainable development, and so forth, aims to address some of the concerns that we have seen in the existing ECT jurisprudence. And moreover, that jurisprudence also kind of can help us understand what would be the key lessons for future disputes, especially those concerning fossil phase-out questions and situations which might arise. The Netherlands, the recent dispute against the Netherlands might be a first in line of many of such cases. So it's a continuation of a discussion that we had last Friday, and hopefully opening some new interesting questions, not just in the context of the report, but also having a broader impact. And before we kind of start the discussion, I'd like to once again welcome Anja as our guest. Thank you very much for taking the time to join us. And in case you haven't been familiar with Anja and her work and generally the Climate Change Council, I'd just like to take a few minutes to read Anja's bio and introduce her to our audience. So Anja's work focuses on the intersection between international investment law and climate law. Prior to co-founding Climate Change Council, Anja served as legal counsel at the Arbitration Institute of the Stockholm Chamber of Commerce and was an international disputes lawyer in New York. She also spent 6 years as a writer and editor at policy-oriented think tanks in Kabul and Washington, D.C. Anja holds a JD from Columbia University in New York, where she was a Paul and Daisy Soros Fellow and a recipient of the Parker School Certificate in International and Comparative Law. She also earned an LLM in International Criminal Law from the University of Amsterdam and served as a summer clerk at the International Criminal Tribunal for Rwanda. Anja sits on the board of the Swedish Association for Responsible Consumption and is a dedicated yoga practitioner and teacher, which is wonderful.
Wow,
so
that's
welcome.
Like
that's a full bio.
Full bio. That's it. I also like vegan food, and I have 2 kids. Yeah.
Okay.
No.
Yeah.
So I want to. Can I say something though? Because I've turned off my self view, so I can't see myself because I find that very distracting. But I also have a tendency to move around a lot. So if at some point I've like moved out of the screen, just flag and say, Anja, we can't see you. Or okay. If I'm like outside, yeah.
No problem.
So I can't see myself. Anyway, no, thank you so much for having me, and I'm very excited to see that we're joined by a group of people here.
Right, so this is our usual turnout on Friday, but that's why we aim to record the session just to give our audience a more opportunity to maybe, even irrespective of whether they are here or not, just to have an opportunity to kind of re-listen to the discussion. So we've discussed quite interesting questions before the webinar, so I like us to take maybe a kind of a slow pace at the beginning and warm us up for what will come next. So let's start by discussing briefly the report that attracted a lot of attention, rightly so. And I think it would be interesting for our audience, at least for those who haven't had a chance to go through it in great detail, to understand what was the motives in producing the report, and whether and to what extent you found or encountered any challenges in producing the report. So what was the final outcome and kind of the methodology that you undertook?
So thank you. I must say that I'm so pleasantly surprised that this report has received so much attention, like just the way you're talking about it now. And we have received very, very positive responses since releasing it in mid-March. And so the idea was when we first sort of framed the study, it was almost a year ago, I guess now, we had this idea. I mean, the overarching purpose of the study was to better understand the interaction between the ECT and energy transition. And as I'm sure you know, I mean, the ECT it's a very polarizing issue. This treaty is such, and even polarizing in mainstream, in the mainstream media, right? So there are a lot of NGOs saying this is the biggest obstacle to energy transition. And do you know that private investors can sue states for trying to do something about climate change? And then on the other hand, you have, the people working the system that say this is an absolutely necessary piece of the puzzle in investor protection. So it's an extremely polarizing issue, and so we worked on it, my co-founder Annette and I, we worked on issues of sort of the intersection of climate change and investment arbitration already when we were at the Arbitration Institute at the Stockholm Chamber of Commerce. So our idea with the study was to look at, okay, this very polarized debate around the ECT, to what extent is it actually reflected in the jurisprudence? Like if we look at the jurisprudence, what is actually there? So that was sort of the background on how we came to it. And so our idea was to map climate and energy transition issues in the case law under the ECT, and to see. Anyways, I'll stop with the background. There's a lot of background. But so what we did is, we set out to assess just the prevalence or the occurrence of climate and energy transition issues in the case law. Questions like, have tribunals actually applied the environmental provisions that are in the treaty? Have they talked about or discussed climate change at all? Right? Is there any, to what extent, in what context, and so on. So, and then our second idea was to explore the interaction between the ECT and other treaties in the case law. And of course, the underlying question there being, how do you, when two treaties conflict with one another, like, we'll talk more about this, but like the Paris Agreement and the Energy Charter Treaty, how have tribunals tried to balance those two treaties or multiple treaties against each other? So that was our second sort of thing that we wanted to assess. And then the third area of assessment was to look at investor protection versus the state's right to regulate. And from the beginning, it was like we thought we would focus on the environmental or the climate context, but of course we found fairly quickly that there was nothing there. So we just expanded the scope to saying, okay, in all regulatory disputes, how have tribunals looked at, investor protection on the one hand and balancing that against the state's inherent right to regulate. So, and then we also wanted to see, to what extent amicus briefs have been filed by actors other than the European Commission in these treaties. So what we did, just a few words on the methodology. So we wanted to look at as much of the case law as possible under the ECT. And at the time, so our cutoff date was August of last year. And at that point, there were 75 known awards under the treaty. And we tried to get a hold of all of them. But even with all of our connections at the various institutes around the world, we could only get a hold of 64. And a few of those, and then we also had access, we could pull some information from the other ones, but we didn't get access to the full text of anymore. So 64 awards. It's still a large body of awards. And so what we did before reviewing the awards, we talked to a lot of stakeholders. So we talked to policymakers, we talked to people involved in the ECT modernization process, we talked to professors, academics who have written on this, we talked, of course, to a lot of arbitrators and people who appear as counsel in ECT cases. And we also talked to civil society actors, the ones that have been the most vocal on the issue of ECT are Client Earth and the Center for International Environmental Law, SEAL. So we talked to them as well. And we asked them what would be beneficial for them to if we are to pull out all this information from the cases, from the awards, what would be beneficial? What would you like to see? And so based on those, we let those interviews influence our methodology. And then we, from there, embarked on like a textual review of all the cases. Maybe I'll stop there.
Right, wonderful. I think it's, so what I see is like we can go in three different directions.
Mm-hmm.
And I'd like us maybe to start off by looking at this interaction between ECT and other instruments. What I found quite interesting is that the results, and I understand that you know it's a large pool, although it could have been expanded, and maybe in the future it will be expanded. But out of the 64 awards that we reviewed, there was no mention of climate change, or there was no mention of policy around climate change, environment, and so forth, in a way that would influence the tribunal's decision on a specific case. And what I found very interesting is that, you know, and this is something that we discussed as well, ECT, at least as it currently stands, it's not absent of a provision that would allow that bridge between ECT and other instruments. Quite the contrary, it has a provision, you know, that requires the tribunals to interpret it in line with rules of international law. There's also the provision in the VCLT. So, and plus different aspects of the ECT could allow for a systemic interpretation that could yield that bridge. And if that hasn't been done, so I mean, there are at least two questions that kind of come out of this. So the first one would be, what is the role of ECT in climate change transition and transition to green economy if there is no acknowledgement between that bridge? And of course, then the big question is it really about the treaty, or is it the interpretation and the interpreters of the treaty in these cases? So how can we go about in finding that balance?
Yeah, there's a lot in what you just said. I'll just take one thing and then you'll have to remind me of the other things. But I think that when it comes to why that bridge, as you call it, between the ECT and the Paris Agreement, for example, why that bridge hasn't been made, I mean, when I look at the case law so far, there just haven't been any climate related disputes. So we shouldn't put too much emphasis on the fact that these arguments haven't been made. Maybe the arguments haven't been made, or these issues haven't been debated because the disputes simply haven't been climate related. And that was one of the big findings, not a big, but one of the primary findings, I guess, from looking at this body of jurisprudence, because you would expect that the ECT is the main treaty, investor protection treaty in the energy sector. And there's a very close connection between energy transition, or the energy sector, and climate change. So you would expect that there would be more, disputes like that specifically like came within the boundaries of this intersection, but there just have not been. So I think I have to look at my notes. I think there were 20 fossil related.
20.
20 out of the 65 were fossil related, right? But none of those fossil related cases were about, you know, issues related to climate regulation, or there are some pending cases. There's one against Italy called Rock Hopper. So people tend to group that into like a climate related case or an environmental case, because Italy, the challenge state action is that Italy has refused a permit for Rock Hopper to drill within a certain distance of the shore, right? So that would be a potential like climate related or environmental related dispute. And then we have these 2 cases against the Netherlands that are pending. But other than that, all of the fossil cases have been, they have not been regulatory disputes. They've been about some isolated state action that just doesn't lend itself to this type of analysis by the tribunals. So that's sort of one fact in and of itself, that like the fossil cases that we've seen so far actually do not reflect that, they don't have any climate aspects to them. And then then of course, as everybody knows, we have all of these renewable energy cases against Spain, Italy, and the Czech Republic. And so in those cases, of course, climate change is mentioned, or at least the UNFCCC, the convention on the framework convention on climate change is mentioned, but it's only mentioned in the background, because these disputes are not climate change related at all. They're budgetary disputes. So of course, in those cases, even though Spain, the original incentive for Spain to come up with these schemes to attract renewable energy investors, that had to do with climate change. But the challenge regulatory measure, which was their amendments to those schemes, that was a budgetary concern. And so there was just, in those awards, in those cases, there just was no real place for like the climate change issues to be debated. And that's why now when I look at the current cases, the 2 cases that we have against the Netherlands, these are the test cases. This is where we will see, I mean, I certainly hope that the counsel for the parties will argue, or counsel for the Netherlands will argue the most obvious, like this clash that you speak of between international climate change law, the obligations that the states are under the Paris Agreement on the one hand, and then on the other hand, investor protections, right? So now these cases are the first cases where we'll have to figure out the boundaries between investor protection and the state's right, and in some cases, I would say their obligation to regulate for climate action. I have a lot more to say, but I'll pause there and you'll steer me in some direction.
Yes, I absolutely agree with you. I think that the Netherlands cases are definitely test cases, and I'm interested to see the outcome, because looking at the case of Netherlands in the context of strategic climate change litigation as well against the government and corporations, I mean, Netherlands has been taking, or at least arguably you can say it's one of the progressive climate change policy states. So it would be interesting to see how that will, what will be the outcome of these disputes, and what kind of message would that send to other countries maybe looking to do the same thing. But given that is, do you have something?
No, I just want to say, you and I are now talking about these cases, assuming that everybody knows exactly what they're about.
Right. So do you want to give a bit of a background?
Yeah.
Go ahead.
Because when I attend seminars, I absolutely hate when people assume a level of knowledge and that I don't have. So I just wanted to say that it's actually in a larger context, right? That like you said, the Netherlands has been very central in climate change litigation. So the there was a big civil society case against the Dutch government called Urgenda, and that case went through all. So basically, this civil society organization was arguing that the Dutch government wasn't doing enough to achieve its obligations, its goals under the Paris Agreement. And the case was successful, and it went through all three levels of the judiciary, and even the Supreme Court agreed with the claimants and said that the government had to do more, had to act in order to do something about climate change and get closer to reaching the targets under the Paris Agreement. So what does the Netherlands do? The Netherlands is then required to act. And part of that action was passing a law in 2019 to phase out coal-fired power plants. And then, of course, so, and from discussions that I've heard, I understand that, of course, the Dutch government had negotiations with investors before passing the law. But nonetheless, once the law was passed, first there were threats of claims, and then there were actual claims filed under the ECT. And then, unfortunately, due to the absolutely moronic confidentiality provisions, we don't know what's in the claims, right? So the statement of claim has been filed in one of those cases. It was filed in December, but we don't know what the investors argue because, as always, there's no transparency, which I think is unbelievably problematic in and of itself. So, but anyways, I think we can assume that what the investors are arguing is that, you know, the law amounts to an indirect expropriation because it affects the value of the coal-fired power plants. And then we can also assume that they are arguing that passing the law amounts to a violation of the fair and equitable treatment standard as it currently stands, importantly, as it currently stands under the current version of the ECT. And this is, I mean, I assume that this is the case, and this is exactly what everybody has been expecting to happen. And it really goes to the core of why the ECT is problematic for a climate transition.
Absolutely. I mean, just to make a slight comparison between the Uganda case in the Netherlands versus a recent case in Belgium, I mean, the facts and the arguments and the scenario is more or less the same. A civil society group brought a claim against the Belgian government saying the same thing. You know, the Belgian government is not doing enough in the context of combating climate change. It needs to do more. But the Belgian court didn't go as far as the Dutch court, in the sense that they didn't go as far as to say, well, we're ordering the government to take action. They simply acknowledged that exists and allowed the claim to proceed. It would be interesting to see whether the final outcome in that case will stay the same. So if the higher instance courts will approve the first instance court's reasoning or not. But given that in the Netherlands, the whole kind of policy framework originated from a strategic climate change litigation, it would be very interesting to see if that plays a role in the tribunal's assessment of fair and equitable treatment, legitimate expectations, expropriation, and so forth. And that's why these cases are quite interesting, at least insofar as we can assume or predict what goes on behind the closed doors. Now, I'd love to talk about transparency, but I feel like that will derail us further. So I want to go back on if with the two cases against the Netherlands being the test cases, what would be kind of some of the key takeaways or lessons that we can take from the regulatory cases, although they are indirectly related, or at least in the general conception, they fall under this climate change umbrella or sustainable development umbrella. There's a lot of people put a lot of things under these terms. But if we do separate them, what would be some of the key lessons that you think might influence the tribunals in the phase out cases?
No, that's a very good question, because of course, you know, like in the context where there is no direct precedence for for the tribunals in the FACE-out cases, of course, the tribunals will look at analogous cases, both the analogous cases under the ECT and also, of course, under other treaties. So in looking for analogous cases, which cases will be the most applicable? Of course, it will be the prior regulatory cases. I mean, these are just for, again, to make sure that everybody knows what we're talking about. Regulatory cases are cases in which an investor challenges the host state's introduction, amendment, or I would say also abolition of a regulatory measure, right? So they argue, basically the investor argues that this new law or this new regulation has a negative effect on the value of their investment, and therefore it violates the investor protections under the ECT. So again, so you may think, well, aren't all cases under the ECT regulatory? Because those are the ones that you hear about, right? And because that's where again, where mainstream media comes in, where civil society comes in. The regulatory cases, because they have to do with like the democratic, the exercise, the state's exercise of its powers, like police powers and democratically elected governments, right? That's why those cases are the ones that tend to get the most attention. But of course, many cases are not regulatory. You know, they'll be about other types of state action, like denial of a permit or rezoning of a land area, or very specific things like that. But so in the climate case context, of course, these regulatory cases are the ones that are the most important to look at. Those are the ones that, if we look at those, we will, as your question was, we can draw some key lessons or perhaps hypothesize what may happen with these climate-related phase-out cases. So in the study, we classified 40 out of the 64 awards as being regulatory disputes. And so when you talk about like what we can learn from, and most of those, I should say, the vast majority of those 40 cases were relating to these renewable energy cases. Sorry, does everybody, have you talked about the renewable energy cases, or should I do like a super brief like summary of what those are about?
However you feel comfortable. A brief summary would work.
I will. No problem. There are almost 40 cases under the ECT. So actually almost the majority of the body of case law under the ECT relate to a very specific sets of cases. And very briefly, what happened was that the Spain, Italy, and the Czech Republic, but let's just say Spain because most cases are against Spain. Spain, in order to attract renewable energy investors, came up with an extremely ambitious and generous incentive scheme, offering, feed-in tariffs and all kinds of guaranteed profits over a very, very long period of time. So it may not have been the smartest move by Spain. Like, I don't think they really thought through the consequences of that piece of legislation. And of course, then what happened is that it attracted a ton of investors, which made the whole thing economically difficult to sustain for Spain, because it became, like I said before, a budgetary issue. So all of these, so the claims then, these regulatory issues, are not about the incentive scheme, but rather about the amendments to the incentive schemes. And so that's also, sorry, now I'm jumping a little bit. So one reason why I think it's difficult to draw lessons from those cases, from the regulatory cases that have to do with the renewable energy incentive schemes, I think it's difficult to draw lessons from those cases to the phase-out cases, because they're so specific. In all of the renewable energy cases, the state had actually done something to positively attract the investors. And of course, when you look at in the fossil sector, no state, you know, has like, there are no incentive schemes in the fossil fuel sector. So where was I going with that? Hold on. Yes, but we can still, of course, the claims are still the same, right? Even though, of course, like with the idea that you can't draw clean lessons between the two, you can still look at how the tribunals have reasoned in the particular claims. And all of the claims are basically indirect expropriation and fair and equitable treatment. Some of them frame it as an unreasonable and discriminatory measure, and there's like claims under what's called the umbrella clause, but more or less the analysis is the same. The fair and equitable treatment clause is basically encompasses it all. But first, on the indirect expropriation, and I think this is, so indirect expropriation claims have really never been successful. The threshold is very, very high, and that was set before the renewable energy cases, and it's been maintained at a high threshold even through the renewable energy cases. So in order for a regulatory measure to amount to an indirect expropriation, it has to basically be unrelated to a public policy purpose. And I don't think anybody's going to argue that climate change mitigation adaptation is not, you know, anything that a policy related to that is by definition going to pass that threshold, right? It's going to, like, it's related to a public policy purpose. And then they also, most of the analysis in the indirect expropriation analysis, the tribunals also require that the regulation has to have the effect of depriving the investor of the value of the investment or the enjoyment of it. And what that means is that you have to be completely deprived. So it's not enough that your profits go from awesome to mediocre, right? It has to be like, you have to have completely lost any value, or lost all its value. And if you look at the coal plants, for example, in the Netherlands, they're going to keep, the investors will keep deriving some profit from them until the year 2030. And even after that, there are retrofitting alternatives. You can change the coal plants so that they emit less CO2, and thereby you can keep, I mean, of course, it will reduce your profits, but you haven't been deprived of your investment. So in previous regulatory cases, the claim of indirect expropriation has failed because these are very, very high standards. And I would expect that the same would be true for these phase-out cases, that the claims of indirect expropriation will probably fail for the same reason. And then let me also say something about the fair and equitable treatment. And also I want to talk about due diligence, maybe now, maybe later. But so under the fair and equitable treatment standard, of course, as you mentioned before, the analysis is all about legitimate expectations. So the question is, you know, at the time of investment, was the investor entitled to holding legitimate expectations that the regulatory framework would remain the same? And so this is really why the renewable energy cases are of limited value when it comes to the analysis in the phase-out cases, because of course, when the investors saw these incentive schemes, at least you have an argument that the incentive scheme created a legitimate expectation that they would remain unchanged. And as we can talk about more if you want to, of course, whether or not that was enough, like tribunals do not agree whether the fact that there was an incentive scheme is enough for the tribunal, for the investor to expect nothing to change, right? But then some tribunals have called that you need what is called a specific commitment of stability. And so when you look at the phase-out cases, I mean, I don't think anybody could argue that if you, okay, this kind of goes into due diligence, right? So investors can't, a regulatory change that is foreseeable at the time of investment can't be a violation of your legitimate expectations. So as when you're an investor and you're about to make your investment decision, then you have a duty of due diligence to look at the entire regulatory framework affecting your investment and thinking, is this going to remain stable? And arguably, if you do that, if you're an investor in the fossil sector, you can't say, I didn't know that they were gonna, phase out coal.
Absolutely.
Not in 2007, not in 2015, not any time since 1992, I would say. Okay, sorry, I have talked a lot.
No, that's excellent. I mean, I agree with you. I don't think how you can reasonably make an argument that, at least in the context of fossil fuel regulation, that you cannot expect that the regulation will change. But again, it remains to see. Remains to see. We'll have to wait and see how the tribunals, at least in the Netherlands cases, decide. But I want to go back to the Spanish saga, or the Spanish cases. Right. You mentioned something that I think there are two things that I think we can dig a little bit deeper into. So on one side, not all, I mean, the factual scenario in these cases is more or less the same. The regulatory framework is more or less the same. The treaty under which these claims are brought is the same, and yet we still see inconsistencies and different approaches in how the tribunals apply and interpret the ECT. I mean, can it, this is just a brief follow-up question, can we then, even if there are lessons to be taken, can we really talk about lessons that, can we really talk about unanimous lessons, since they're simply inconsistency? I mean, it really, it depends on the tribunal.
It depends on the tribunal entirely, and this is, I mean, I worked in international arbitration and investment arbitration for 10 years. And so it almost pains me a little bit to say this, but these are not neutral decision makers, right? And that might be fine in commercial arbitration because they're experts and, they're appointed by the parties and so on. But when it comes to investor-state arbitration, and when it comes especially in regulatory disputes, when it comes to evaluating whether or not the state has exceeded, the boundaries of its right to regulate, I find that it depends, like you said, it depends much more on the arbitrator's background, ideals, proclivities, than it does on the circumstances of the case. And I find that very problematic. Right. So for those of us who work in the system, I mean, I don't anymore, but when I did, you could almost predict the outcome of a case depending on who sat in the tribunal, more so than based on, the facts of the case. And I don't know, I find that to be quite problematic. Now I'm going way beyond the neutrality of the study, but yeah.
I mean, so what I find interesting is that there was a study done by an English professor. He reviewed ISDS cases, not necessarily ECT cases, and he found that in most of the cases where a professor would sit on the tribunal, they were more inclined to look at or seek that systematic interpretation of the BIT or the instrument in question with other international agreements and instruments that the state has in cases that concern environmental, human rights protections, and so forth, compared to a commercial law arbitrator. It seems that there is a difference in how they understand their mandate to be, and that influences the scope of the analysis. And I mean, there are some disturbing decisions outside of the ECT where, irrespective of what you have in the treaty, it still doesn't guarantee that the outcome will be the one that the drafters of the treaty might have intended. But that will get us beyond our discussion today.
I absolutely agree with you.
But I think it's important to emphasize that, you know, it's not just about the text, but it's also the people who are interpreting this is also an important factor to consider, alongside with transparency and just other elements of the proceedings that kind of serve that broader public interest that lies behind investor-state cases.
I think so. This one of our actually, this came up a few times in the stakeholder interviews that we did as part of the study, when we discussed with people the mandate of the tribunal to interpret the treaty and how they should do so, how a tribunal ideally should balance the treaty protections, the ECT protections, against seemingly conflicting obligations under another area of international law. And several people, one in particular who works very closely with, he's like a tribunal secretary who has worked with many senior investor state arbitrators. And he said the arbitrators are always going to prioritize the treaty that gave them their mandate, right? Their mandate arises out of the ECT. That is the law that they see themselves as bound to apply. And so, yes, in theory, international investment law is on par with international climate law. They're both separate areas equally applicable under international law. But he said their mandate arises under international investment law. They are not going to apply. They do not see it as part of their mandate to apply international climate change law. So in a way, I guess, I mean, relatedly, you'd have to sort of course they could work in like international law as a fact in their analysis of, you know, what the investors should or shouldn't have known, or whether or not the state acted reasonably. They'll say, okay, yes, we recognize that the state was under this obligation under climate change law, but it might be very difficult to find an arbitrator who's willing to say the provisions of international climate change law or EU climate law trumps the investment provisions. Like basically the people within the system say this is never going to happen. So anyway,
I mean, understanding is right. I think looking at it, at least from the perspective of a fact, it would be, I think that is, I mean, it will be interesting to see whether we will have that development going forward of what would be from kind of fact perspective, the interplay between the climate change and environment protections and all the regulatory framework that falls under the sustainable development umbrella, and standards of protection under ECT or under other instruments of international investment law. We have two questions in the chat that are related to what we've discussed so far. So maybe we can take them up now, and then I'll see if there's a follow-up question on my end. So first question, let me just second. First question comes from Fahira, and it concerns legitimate expectations. So how much attention do tribunals give to the way a measure was imposed by a state as opposed to the foreseeability of such measure? And I think Mr. Abdelgawad, that his question kind of falls into or follows on Fahira's questions, and he gives an example. So for example, what grounds an investor who establishes cement factories running with coal energy can rely on to claim remedies in the case the host state afterward stipulates legislation outlawing the usage of coal in the cement industry. So it's more about that balance between fair and equitable treatment and reasonable expectations versus not so much whether a state has a right to regulate, but how it exercises that right in relation to those expectations. And I think if you could, I'm happy to read the questions again, but you can also see them in the chat.
Yeah,
To what extent the Spanish cases can give some input in terms of exercising that right to regulate in this
can I just I'll treat the questions separately, because the one with the cement is a bit specific. But on Fahira's question, you know, when it comes to legitimate expectations, how much attention do tribunals give to the way a measure was imposed? I mean, foreseeability, I don't know if it's as opposed to the foreseeability of such a measure. I would say that when it comes to foreseeability, that's really at the center of tribunal analysis in most of the cases against Spain, because so some tribunals reasoned that so a few tribunals found that Spain was not liable, right? So that amending these schemes was not a violation of the fair and equitable treatment standard. And they reasoned that the investor should have known that it was foreseeable that Spain would not be able to maintain these incentive schemes for forever. Basically, there was no time limit on many of these incentive schemes. So the foreseeability is crucial, right? The foreseeability aspect in those cases where the tribunal found no liability, then it was to a large extent because they thought that it should have been foreseen by the tribunal. What was the second, by the investor? What was the second part of the question? Was to the way a measure was imposed. Well, the way a measure was imposed, that's actually a very good question, because it goes to something we haven't discussed, which is that the measures, it can't be discriminatory. So as long as a state can't exercise its right to regulate in a way that treats investors differently. But that said, you only have to treat investors that are similar in a similar way. So you don't have to treat investors in the fossil sector the same as you treat investors in the renewable energy sector. But within the fossil sector, you have to be consistent. You can't be arbitrary in how you apply a regulatory measure. That would be a violation of the fair, not would be, but it could be a violation of the fair and equitable treatment standard. So there's definitely how the state, I mean, policy design is like a big thing. Sorry, this is a little bit of a tangent, but I think it's interesting and relevant. How a state imposes a regulation can make all the difference. So Portugal, for example, they also had the same problem as Spain did. They also, I don't know this in any detail, so I'm sorry if someone knows this better than me, but this is secondhand information. But Portugal apparently negotiated with the investors, and when amending the schemes, they did so in a smarter way. Like they had better policy design, and as a result, they weren't hit with any claims. Whereas Spain, when they amended the incentive schemes, they just went about it in sort of a different way.
Right. It seems that the key takeaway is more about how you approach managing your policies and investors as a state, not so much as can you regulate in the interest of, and impose regulatory tariffs. It's more regulatory framework. It's more about how you go about it. It's more about governance, managing relationship with investors, all of those aspects that happen before a claim arises, and the states that have figure that out, so to say, and that have those systems in place of investment care and maintain that regular communication, and they care for their investors, for lack of a better word, they arguably have less cases, whereas Spain, that kind of haphazardly that did it, face a number of cases. I mean, what I find always very interesting is that the one of the latest investors that won a case against Spain in these regulatory tariffs also won an award, and I mentioned this in the last webinar as well, also won an award as being kind of the investor with the best investor in that green transition industry, especially in the solar industry. So it's not those are not cases of, you know, fossil fuel investors versus the state. It's a case of green investors versus versus the state. So,
but I would also like to say, like, on the topic of sort of regulatory space and regulatory chill, I mean, even if it only because they may be hit with investor claims, that doesn't mean that the state cannot regulate. Like, perhaps I don't always understand why the states are so there's this talk of regulatory chill, and recently there were statements, you know, by the Danish climate minister saying that they have been less ambitious, that Denmark, and also same by New Zealand, said we've been less ambitious in our climate policies because we recognize the threat of investor claims. But I would like to challenge that and say, well, sometimes you have to make uncomfortable decisions, right? And instead of just backing down and saying, you know, we're just going to be less ambitious, perhaps you need to say we're going to fight these cases because we believe that we are within our police powers here. And on the other hand, the states also have to recognize that, so they're bound by the ECT in its current form. They made that treaty, all of them, right? They signed this. Sometimes we all make we make bad deals. And so, okay, so if you see the ECT as a bad deal, the way you see like a bad contract, then maybe you have to pay up in order to get out of the pickle that you're in, right? So I don't want it to sound like I think that all fossil investors are bad and that they have no rights under the treaty, because they do have rights under the treaty. I don't know that they could argue, you know, that the regulations that they're now challenging were not foreseeable, but as a matter of fact, they are covered by the treaty in its current form.
Yes, and let's see. All right, and I just want to read a comment from Fahira, who says, thank you indeed. The conversations about the right to regulate is completely misconstrued and serves more as an excuse to defer action. And I mean, on this whole point of regulatory chill, I mean, I absolutely agree with you. I think that serves more kind of as a framework to say we're not going to take any action because taking that action might
be expensive
for whatever reason. Then just as Fahira mentions, use that as an excuse. And I think to your introductory point that ECT is a polarizing treaty, I mean, a lot of the criticism from the civil society, NGOs, it focuses on this, you know, lack of action and the fact that what kind of protection is given, and that the fossil fuel company, that's the activist perspective. That a lot of the regulatory chill and this threat of claims is just another way of exercising the market power, if you will, that fossil fuel companies have. So maybe to kind of as we slowly get closer to our concluding remarks, what can we, expect then in the sense of regulatory chill versus right to regulate going forward, and what are your thoughts on this?
No, something also that we haven't touched upon, maybe you've talked about this in previous seminars, but it's the way that damages are calculated, I think is a very key component, because the reason I think why the reasons why the states feel this fear that causes the regulatory chill is because the potential awards are so massive, right? It's not like $10 million, it's like hundreds of millions of dollars or billions of dollars or euros, right? And so the ECT and most other treaties, you know, they have now, I should know this, but I've read too many valuation provisions, but basically all of these provisions on how the investor should be compensated, they're very broad. They don't say, here's how you calculate, interest, you know, these. So what has happened is, because the treaties are broad, they basically says that the investor should be made whole again. Well, what does that mean? Does that mean that you should be compensated based on the amount of money that they invested? That seems reasonable, but that's not what has happened. What has happened in these cases is, probably some of you, maybe all of you know, is that they're compensated based on their anticipated profits flowing from the investment. It's called the discounted cash flow method evaluation. So that means, and that's why you have claims for billions of dollars, because they say, well, we expected, when we made this investment, we expected to make profits until the year 2050, but you have no idea what's going to happen between now and 2050, right? Regardless or not whether, so what happens in many of these cases is that the investor actually ends up being better off. They get the they get the maximum benefit of their initial investment without having to take any risk, because they get this arbitral award, which is absurd. So I think valuation of damages is a huge topic, and that's something where, back to your original question, like what can states do? Well, one of the things that they could do is because this doesn't require changes in the treaty language. The parties to a treaty could issue an interpretative statement or declaration or something saying, here's how damages should be calculated. They could also, of course, say, here's how the fair and equitable treatment standard should be interpreted, but that one would be much more difficult to find agreement on. But say that you could then, they could specify how damages should be calculated so that you reduce these insanely inflated awards down from the billions to more reasonable sums, and maybe then states wouldn't have this, that would sort of dampen that would I was trying to make it would warm up the regulatory chill, if you will. Yeah. Do you know what I mean?
Yeah, no, absolutely. Melt it down.
Yes.
A little bit. But yes, no, I mean, I think that this discussion in particular puts the previous discussion that we had on the modernization process into definitely a more clear context, in the sense that a lot of what is on the table in the modernization process includes provisions that aim to address this, including a provision on damages, fair and equitable treating, defining it, MFN clauses, umbrella clauses, sustainable development, right to regulate, and so forth. Of course, because of how the modernization process is set up, we don't know the extent or the content of these proposed changes. We only know that, you know, what EU proposed or what is currently being discussed and what kind of progress has been made, but we can't really critically look at them from, you know, an academic or practitioner perspective. So it's yet to be seen whether the revised or the modernized ECT will respond to some of these challenges that we have seen in the jurisprudence and broadly beyond that under this framework. Before I wrap it up for our today's webinar, thank you, and if you have any final concluding remarks that you would like to share with our audience, please.
I do, actually. There's one thing that we haven't touched upon and that I wanna share, and that's, if you take a few steps back and look at this treaty in its context, right? Okay, the question is, does it serve a purpose? Does the ECT serve a continued purpose today, right? And if not, why have states just spent 5 years trying to revise it, and a lot of political capital and energy, right? And we asked this question to all of the stakeholders in our study, and interestingly, people laughed. Even the people who work this system, even like the investment treaty arbitrators and the lawyers, they laughed and they're like, "No, it probably we would probably be better off without it."
Without it, yeah.
Yes. So in a way, I mean, the way I think about it, because I come to this from a climate perspective, when you talk about investment today, the only relevant investment is how do we mobilize the trillions of euros or dollars necessary for climate change mitigation and adaptation. Those are the only investments that I care about, right? And so my question when I look at the ECT is, does the ECT, not does it help, is it necessary? Is this treaty necessary in order to mobilize those investments, the right types of investments? And the truth is that we don't know, right? And what we do know is that the treaty comes at a very high cost, right? Both in terms of defending these cases, potentially paying up awards, and the regulatory chill. Those are like confirmed real costs associated with the treaty. And meanwhile, the treaty has been in existence for, I guess, 3 decades now almost. And there have been a lot of studies, not really specifically on the ECT, but on investment treaties in general, and the connection between the applicability of investment treaties and the flow of FDI. And the studies are very inconclusive, right? So yes, maybe there's a correlation between investment treaties and increased FDI, but we're not sure. And besides, from the climate perspective, it's not just about increased FDI, it's the right type of FDI, right? So I don't know. It's a question that I want all of you to think about, because it's so easy that we think about the definition of like economic activity or the definition of fair and equitable treatment. But if you take a few steps back and you're like, wait, why do we even have this thing? Like, what is it good for? But that said, I don't think it's going anywhere anytime soon. So we should make the best out of it.
Right, and I mean, we'll see where the modernization process ends up, in the sense of whether all of these technical, whether all of these changes will help it become a treaty that is aligned with climate change goals, or whether it will fall short of that. And the preliminary remarks are inconclusive, and we'll see what will be the response of the states, depending on whether or not they believe that ECT reached, or the modernization process reached that goal, and they have diverging approach on that. But to your point, I think absolutely that it's necessary to kind of start flexing our perspective on FDI and standards of protection, both procedural and substantive, in the sense that the socioeconomic and political context of today is different than when attracting FDI was absolutely essential, especially for emerging post-colonial countries to kind of gain their economic growth. And today it's more about balancing different commitments, duties, obligations, because of where we are as a global society at the moment. So this one-sided approach, and this is just my personal view, this one-sided linear approach of we absolutely protect FDIs and the investor and the investment, and that's it. I think we will need to kind of switch it a little bit and broaden the perspective of in that entire context, because otherwise we'll see what happens.
It's necessary.
No, I didn't want to end with like the world will end message, so I stopped there. Thank you very much for taking the time today again. I hope you enjoyed the discussion. I certainly have, and
I hope very much. Thank you.
I hope our audience found it beneficial, and I don't think there's any additional questions, so I thank you all for joining us today, and I wish you all a wonderful rest of the day, and a good weekend.
I just want to say, of course, climatechangecouncil.com, the report is available for download, and we do a lot of interesting things. And so please follow us on LinkedIn if you want to sort of hear more. Yes, sorry, I had to do a little plug.
No, that's okay.
Wonderful weekend.
We will also share a link to the Climate Change Council report on the YouTube video once this recording is available.
Perfect.
And next week we will have Lisa Sachs from Columbia University discussing.
You should all join. She's amazing.
Bringing this discussion into a broader ISDS context. So please stay tuned, and I look forward to seeing you next week. Thank you very much, Anja.
Bye, everyone.
Bye, everyone.